Most people think estate planning is about who gets your money after you die, but there's something that matters just as much. What happens if you're still alive, but you're no longer able to manage your own affairs? Who pays your bills? Who handles your accounts? Who makes health related decisions for you? The answer comes down to one legal document, a power of attorney. I am Asthana, managing partner at Southern Estate Lawyers. We help Alabama families put these protections in place. And we help families that are facing these moments right now. Let me walk you through what you need to know. A power of attorney helps you name someone you trust to act on your behalf if you cannot act for yourself. You are considered the principal, and the person you choose is called your agent. Here's why this matters so much. We're living longer than ever, and a long life often includes a period when we need help managing our affairs. A stroke, dementia, accident, or a serious illness. If that happens and you have no power of attorney in place, your family cannot simply step in. They will need to go to court and ask a judge to appoint a conservator and a guardian to obtain legal authority to act on your behalf. That process is slow, sometimes contested, public, and expensive. And the person that the court appoints, well, that person may not be the person that you would have chosen. There is no one single power of attorney. There are several kinds of powers of attorney. A medical power of attorney allows your agent to make healthcare related decisions for you. A financial power of attorney covers your money, property, and business affairs. A general power of attorney is broad. It can cover nearly everything. A limited power of attorney is narrow. It covers one specific task, like appointing someone to sign closing documents on your behalf while you're out of town. And then there is the question of timing, which is where most people get tripped up. A power of attorney can take into effect in two ways. One takes effect the moment you sign it. That is an immediately effective power of attorney, and it's often drafted to be durable. If it is durable, it comes into effect the moment you sign it and stays effective even upon you losing capacity. A springing power of attorney is a legal document that designates a trusted person to act on your behalf. But this power of attorney only activates when a specific event occurs, most commonly your medical incapacity. Until that triggering event takes place, which is your incapacity, your agent has no authority to act on your behalf. Now, in order for your agent to actually act on your behalf, you almost always need an affidavit or a written certification from a physician confirming that you are no longer able to manage your affairs. So, when it comes to powers of attorney, the agent that you appoint is the most important decision that you have to make. This is someone who can sign your checks, manage your accounts, sell your property, and handle all of your affairs. The right person takes that seriously and acts in your best interest. The wrong person can do a lot of damage, and that is hard to undo. Your agent does not have to be a family member. It can be anyone that you trust. You can name more than one power of attorney. You can also name alternates, a backup in case your first choice is unable to serve. Being an agent is a real responsibility. It's not just a title. Under Alabama law, the agent has a fiduciary duty towards the principal. That means acting in good faith, in your interest, and keeping your money separate from their own. A good agent keeps all records and documents the decisions that they make. An agent that misuses that authority can be held personally liable. They can be ordered to pay you and or the estate back. If you're being asked to serve as someone's agent, make sure to understand that role and the responsibilities fully before you say yes. When it comes to powers of attorney, a few mistakes come up over and over again. The first is waiting too long to create and execute a power of attorney. You can only sign a power of attorney while you have mental capacity. Once a serious stroke or dementia sets in, it is too late to be signing a legal document. Second is using a generic form off of the internet. A power of attorney is a complex, personalized legal document. A form that misses an Alabama legal requirement can render your power of attorney invalid. For example, If a bank rejects your power of attorney for improper execution, your agent is not able to act on your behalf at all. At this point, your family will have to pursue what's called conservatorship in the probate court, a lengthy, expensive process which could have been avoided by working with an estate planning attorney who understood Alabama law. And the third is signing it and forgetting about it, never looking at it again. People change, relationship statuses change, and your plan should keep up with that. Alabama has its own law when it comes to powers of attorney. It's called the Alabama Uniform Power of Attorney Act. To be valid, the document has to be signed by the principal, you, in the presence of a notary. Also, certain powers, like the ability to sell real estate or make gifts of your property, only exist if the document specifically grants them. These are the kind of details generic forms get wrong. As Southern estate lawyers, we will sit down with you and help you create a power of attorney that fits your life, your goals, and meets every Alabama law requirement. We make sure it's durable, properly signed, and accepted by institutions when it's most needed. If your loved one is already incapacitated, we guide families through conservatorship and guardianship. Also, because we are trial lawyers, if an agent has abused their powers when it comes to a power of attorney, we are happy to represent you in taking them to court. We have offices in Foley, Mobile, and Birmingham, and we serve families all across Alabama. A power of attorney really is a gift to the people you love. Our legal team is here to help you with your estate planning needs. Call us for your free consultation, and we look forward to working for you.